to Who Wrote That Up For You, a daily podcast that shines a light on the American justice system and its role in empowering the powerful to take from you. The justice system is the only branch of your government where an individual, rather than the collective, can make the system act for you. It puts power in the individual's hands, but it's broken and being used against you at a time when you need it most.
And welcome to Who Wrote That Up For You. I am Sonia Ebron, co-founder at Courtroom 5.
And I am Deborah Sloan, the other co-founder at Courtroom 5.
Wonderful show lined up for you today. In a few moments, we will speak with Daniel Medwed. He is professor of law and criminal justice at the Northeastern University School of Law. We had him briefly in season 1. We're welcoming him back to talk about his book, Why the Innocent Can't Get Out of Prison. So fantastic conversation. Looking forward to there. But before we get there, Deborah, what is on your mind today? What's our issue of the day?
I want to talk about an opinion piece out of, Bloomberg.com. It's a piece about how to fix the public's confidence in the courts. It's actually at a low, a record-breaking low, particularly because of the Dobbs decision back in June, and just in general, where the courts just don't seem to be fair. And even state courts are there. The people's confidence in state courts, is just lower. And so there's a suggestion that the way to, quote, fix it is to involve juries more, that the public's confidence in the U.S. courts will be bolstered by more involvement of people in court, and in particular juries, because people feel that the jury is more inclined to be fair, based decisions based on the dang law, and that would be fairer than just having the lawyers and the judges go at it. Unfortunately, since COVID, there have been a lot fewer jury trials, and that contributed to the lack of confidence. And so, to get our jurors back, to get that confidence back, we're gonna need to get the jury system working a lot better and having more jury trials. And I agree with that. I think that's a good insight, a very good point.
Yeah, as you know, there are tremendous hurdles to getting in front of a jury. I mean, just
Mm-hmm.
you've got to go through the procedures and procedures and procedures before your case is designated valuable enough for a jury to decide it. And that, I think, is the real
Yeah.
problem here. It should not be so difficult to take your case to a jury of your peers, and so lots of reasons for that. I think we'll get into some of that with Professor Medwed a bit here today. But yeah, I appreciate you bringing that up. That is a huge issue in terms of public confidence there. Well, at Courtroom 5, we believe the courts belong to the people, in particular to the people who use them. And we, the people, are coming to claim our courts. So if you are in court without a lawyer, or you need to sue someone and can't find a lawyer to represent you, get yourself over to courtroom5.com. Try a limited version of our services for free, and we hope to provide some relief for you there. At this time, it is my pleasure to welcome back to the show Professor Daniel Medwed, again, professor of law and criminal justice at the Northeastern University School of Law. Daniel, thank you so much for joining us again on Who Wrote That Up For You.
My pleasure, Sonia and Deborah. Thanks for having me.
It's wonderful, wonderful. Now, you are the author of Why the Innocent can't get out of prison. And I know you have spent substantial part of your career working with the Innocence Project. In particular, I believe you're on the board of the New England Innocence Project, working to get the innocent out of prison. And it shouldn't take so much work.
Yeah.
Why is it so difficult for actually innocent people to get themselves out of prison?
Well, it relates a little bit to what you and Deborah were talking about before, how the trial is so important. And our entire system is predicated on the idea that the trial's the main event. In fact, the Supreme Court has a case from 2017 that says that. The trial is the main event. That's where there's a presumption of innocence. That's where there are supposedly all these safeguards. But once you're convicted, that presumption flips. Instead of being a presumption of innocence, there's now a presumption of guilt. And it becomes that much harder to reverse that presumption because everyone assumes that the trial got it right, that all of those protections actually worked out. That's the biggest fallacy, I think, in our system, that the trial is an effective mechanism for sorting the innocent from the guilty. People make mistakes at trial, and there's an amazing sort of what I call diffusion of responsibility, which is at trial, maybe prosecutors, defense lawyers, trial lawyers, and jurors can all say, well, we're trying our best, but if we make a mistake, there's somebody down the road who can look at it and make sure that they can reverse it. But then the people down the road are saying, well, the people before at trial, they were in a better posture to evaluate everything on the front end, so I'm going to defer to their decisions. So essentially, because of those underlying sort of theories, it becomes very difficult. Those theories then are essentially made concrete by a number of procedures in the post-conviction and appellate process that make it really difficult to get new evidence into court.
That
That's
is
the short version.
extraordinary. That is, I know. I know. It's the very short version. And you're right. We do put a lot of value on that trial, on that jury process, right?
Yeah,
And we do understand you want to get your case to a jury, and the jury's gonna, be the ultimate arbiter. But those procedures, I think, getting to a jury can really constrict the facts available to that jury to weigh. And so I think you're right. They don't always get it right,
that's
for a
right.
variety of reasons. We focus, I think, at Courtroom 5 most on the civil side, but this
Yeah,
is even more important on the criminal side, particularly when you have the state versus, right? The state with all its resources
that's right.
versus people who largely have budget limited public defenders,
That's
or
right.
even criminal defense that you have to pay for out of your own pocket. That imbalance really limits the fairness of that jury process, of that trial process. And so, I can
Yeah.
see juries getting it wrong,
Oh,
right?
they can get it wrong. It's funny when I was a public defender in New York and I was in the appeals bureau of my office, and we had a group, I can't remember, maybe 40, 50 lawyers, and we could only afford a half-time investigator, a part-time investigator who didn't have a driver's license. Uh, Now in New York, you do need a driver's license to get to some of the outer boroughs, right? So instead, we lost a lot of money when he would seek reimbursements for taxis.
Right,
But so we had to actually pay for our investigation, substandard investigation. If the prosecution wanted an investigation, they just had to call the NYPD for free, you
right,
know, and
right,
it just the imbalance of resources and the imbalance of power. And one of the ways in which this plays out, Sonia and Deborah, is that there are a lot of incentives to plead guilty.
right,
Just as there are incentives to take a settlement in a civil case because if you're risk averse, you might not want to go to trial. In a criminal case where the stakes are even higher, right? Because you're facing a potential loss of liberty. If the prosecution offers you 3 years in prison and you're looking at 15 if you lose at trial, if you're at all rational and careful and cautious, you're going to take that deal even if you're innocent. So
yeah.
this myth of the American trial as the arbiter of guilt or innocence, as a truth teller, is really, I think, a lie, or at least a fabrication. And I think, of course, it's especially bad for people of color.
Yeah.
as we all know, who don't get much of a fair shake at all in our system, let alone in the criminal justice system. You mentioned juries, Sonia, a moment ago. Prosecutors for years have come up with very deceptive practices to try to craft juries that might potentially be hostile or at least not sympathetic to defendants of color. It's really a
Right.
problem.
Right. Absolutely. A horrible problem. Absolutely. Let's talk a bit then about, so you've got your jury verdict, you've been
Yeah.
convicted. What is the process now of getting that corrected if you're innocent?
Excellent. Well, there are a couple different processes. There are really three different processes. One is the direct appeal. As a matter of statute, actually not as a matter of constitutional law. There's no reference to the appeal in the US Constitution. It's kind of puzzling. You have a right under state law to appeal your conviction once and once only to a higher court. It's called the direct appeal, and you're really limited in the issues you can raise. You can't go outside the trial record, what was presented at trial. Can't bring in new evidence. So that's not a really good vehicle for overturning a wrongful conviction. You can't introduce new facts. If you lose that direct appeal, you can sometimes petition to a higher court, but that's discretionary. It's not automatic. The second route is also in the court system, and that's what's called the collateral or sideways post conviction process, where you attack the conviction from the side, sometimes with new evidence or new arguments, through something called a writ of habeas corpus or something called a writ of error coram nobis. The idea is you go back to a trial level judge and you try to make arguments that you were somehow deprived of your constitutional rights, or there's newly discovered evidence that casts doubt on the legitimacy of your conviction. But there are lots of procedural hurdles to prevailing in those arenas. So the third bucket, sort of the third route, is through the executive branch, where you could petition for parole or you could petition for clemency, basically a pardon or a sentence commutation. This is full of landmines, though, too, because in this part of the process, they're looking for essentially an acceptance of responsibility. They want to extend mercy or forgiveness, and that's the basis for getting parole or getting a pardon. But if you're innocent, how can you accept responsibility
Right.
for something you didn't do? So
Right.
you're not necessarily singing the tune that they want to hear in this process. And paradoxically, it seems like the guilty, who can feign crocodile tears and claim to be remorseful, might even do better in these executive branch processes than the factually innocent, who might stick to her guns and say, I didn't do this. I'm not
Right.
sorry
Right.
because I didn't do it.
So
Those are
let
sort of
me
the three major avenues.
Extraordinary. Those are significant hurdles there. If I understood you
Yes.
correctly, you cannot, on direct appeal, introduce evidence that wasn't introduced at trial.
That's
No
right.
new evidence.
That's right. It's even worse than that, Sonia, because you typically can only raise issues that were preserved for review by the attorney. So when that trial attorney objects, they're not only trying to get the evidence out, so maybe they can
Right.
win at trial, but they're trying to what's called preserve the issue for further review. And
Yeah.
if you object, the idea is that the trial judge will make a ruling and it might be efficient and resolve the issue then and there. So sometimes you're limited even in the issues from the trial record that you can raise on appeal. And if the issue came up, but it wasn't objected to, sometimes appellate courts won't touch it.
You're
So
right.
it's really narrow, it's really limited.
Wow. That needs to be fixed. The
Yes.
second option, I forget the collateral attack.
Yeah.
There, you can only introduce evidence that is newly discovered. Talk more about that. What's
Yeah.
the threshold there on newly
Excellent.
discovered
So,
evidence?
so it depends a little bit on the procedure, Sonia, but the famous writ of habeas corpus means, we have the body, and
Oh,
it's a way for you to ask the government to justify why they have someone in detention. And you can challenge a conviction under habeas corpus by basically saying, hey, the government is keeping my client, or if you're filing pro se without a lawyer, and you know about that because Courtroom 5 is all about getting representation for people who don't have lawyers, but a lot of people don't have lawyers and they have to go pro se. You can force the government to justify that. And you can sometimes present new evidence of a constitutional violation. right? Something happened in the jury room, or my lawyer did something inadequate that I just learned about. But the other procedure is, it's called a coram nobis procedure, where you present newly discovered evidence that suggests it might be a flawed conviction. And the hurdle is really high, Sonia, as you suggest. You often have to show not that just that it was new, that this is new information that wasn't presented at trial, but it's newly discovered and couldn't have been found before trial, that it
Oh,
couldn't have been found with due diligence at the time of trial. So sometimes you're between a rock and a hard place, right? You find new evidence, but your lawyer before could have found it. That wouldn't count as newly discovered. So then
oh,
you say that your lawyer was ineffective for not
right.
discovering it, but the court, because the standard for proving an ineffective lawyer is so high, the court will say, no, your lawyer wasn't really ineffective. So sometimes you're in this weird netherworld between newly discovered evidence of innocence and ineffective assistance of counsel. It's a real conundrum.
That is horrible. That is horrible.
Yes,
Unworthy of a great nation, for sure. The third
I
option,
well
then,
said. You're right.
what is the probability of getting clemency if you're actually innocent? I mean, you have to then prove to what, the governor, that you
Yes.
you know
Yeah.
that you're innocent of what a jury said you're guilty of. I mean,
It,
what's the chance of that?
the chance is very minimal. I mean, for a couple of reasons. One relates to something we talked about a moment ago, which is the purpose of clemency. It's all about forgiveness or mercy. The whole term clemency, I find the history really interesting. It dates back to ancient Rome, and the goddess Clementia, the goddess of mercy. And Julius Caesar would often cite the goddess of mercy, Clementia, to spare the lives of fallen soldiers that he defeated on the battlefield. And the idea behind clemency is like to forgive people who are your enemies and to show that like you're on the higher ground. It's like, the Michelle Obama statement, when they go low, we'll go high. Clemency is about going high and forgiving people, even those who've hurt you.
Yeah,
The purpose is not to correct a mistake. It's
right.
not to, help the innocent. It's really to help someone maybe who had a really bad childhood and they did something wrong, but they've made amends for it while in prison and they've taken steps toward self-improvement. So that the orientation is not really geared toward innocence. But some clemency boards have special pardon for innocence procedures, and the standard is really, really high. And as you point out, Sonia, you have to convince a governor or an administrative board that you deserve it. It's really rare. Even, I'm calling from Massachusetts, and we're supposed to be a blue state. We're supposed to be progressive. Not the case when it comes to pardons. Between 2003 and 2021, I think there were only something like 6 pardons for 3 different governors. One of them was
Mm,
Mitt Romney, but another one was Deval Patrick, who is pretty far left, a Democrat, progressive,
yeah.
and he only issued a few of them as well. So, clemency isn't this great remedy for a lot of innocent people.
Wow. Yeah, absolutely. So I want to talk about how to fix this mess. But before we
Yeah.
do, what is when you go to trial, if you can't afford an attorney, one will be appointed for you. We've all heard
Yes.
that. What is does that happen on the appellate level once you've been wrongly convicted? Do you get a
Yeah.
free lawyer?
It's an interesting point. Here's how it works. So that right to a lawyer at trial is a right to a lawyer in a criminal case that could lead to imprisonment. So in
Right.
a lot of misdemeanors, you might not get a lawyer, as you know,
Mm-hmm.
but for cases where you can get significant prison term, you're going to get a lawyer. The Supreme Court has also extended that right. That right comes from Gideon versus Wainwright, 1963 case. They've extended that right to that direct appeal. As I mentioned,
Ah.
you have that right to a direct appeal, and you can get a lawyer for that. And that's actually what I did in New York. I handled the direct appeal as a public defender for indigent clients. But get this, Sonia, there's no right to a lawyer for the post conviction or collateral remedy process. You're going to either fly solo, or you have to convince a judge to appoint a lawyer for you, or you have to convince an Innocence Project to take on your case pro bono. And as you can imagine, there are many more people requesting assistance out
Yeah.
there than people who are willing or able to provide it. So a lot of times you are going pro bono in trying to prove your innocence through the collateral process.
And this may vary state to state, but what is the standard for getting a judge to persuading a judge to appoint you a lawyer for the
It's
collateral
yeah,
attack?
that's such a good question, and it does vary from state to state. And basically, the idea is, in some states, my understanding, and I'm not an expert on a specific standard, but my understanding is you have to convince a judge that you have a credible case, right? You have to make a preliminary showing that it's a non-frivolous petition or filing. Now, that's a problem, of course, because let's say you're not a lawyer, you don't have training in law, and so you're filing a motion to try to get in the gate. I mean, are you going to write the perfect motion with all the right legalese and forms and citations? No.
Wow.
So then a
Yeah.
court's going to say it's probably frivolous. They're not going to be in a good position to evaluate whether it's credible or not. So there's a little chicken or egg problem in terms of getting a court to give you a lawyer.
Wow. And
Yeah.
one last question on this issue. Is this a civil proceeding or is it considered part of the criminal law?
I'm glad you asked that. It's often considered a civil proceeding. Habeas corpus, in particular, is under law. It's treated as a civil proceeding, and it's sort of outside the criminal context. So it's really up your alley, I think, Sonia and Deborah, in terms of your fight for a civil Gideon. You
Yeah.
know, your
Yeah.
fight to give civil litigants access to counsel, access to information. I think
That's
it's part and
fantastic.
parcel with this whole fight.
I love it. I love it. I'm going to make that argument to some of our investors. That's
Please
fantastic.
do.
Well, then let's talk then about how we get out of this mess because innocent people should not be imprisoned in any democracy. How do we fix this?
I think there are a couple ways to fix it. I mean, one is what you're doing, what we're doing right now, which is just education, just talking about it. It's often said that sunlight is the greatest disinfectant. And as you guys both know, people in this country tend to think that we have the best justice system in the world without actually learning about it or
Yeah.
reflecting on it or talking about it. So the first thing we can do is just talk about it and keep it real and explain, look, after trial, your odds of proving that you're innocent go down a lot. And even at trial, they're not so good. So we can invest more resources to make the trial a better and more accurate forum. But in terms of specific remedies, I have a whole bunch of them. I have both macro level, like big picture remedies, and micro level ones, sort of minor remedies. The little ones are pretty easy. And Sonia, you already identified one. Why should there be this rigid preservation requirement in raising issues on the direct appeal? Why shouldn't a judge on appeal have a lot more leeway to look at the trial record and decide whether a mistake might have been made, regardless of whether the defense lawyer objected? So there are lots of little suggestions like that I make in the book, changing standards of review, things like that. In terms of big picture changes, I present a few of them. One is that we could have prosecutors set up their own conviction integrity units where
Yeah.
they could look at these cases. Prosecutors are supposed to be ministers of justice. They're supposed to win as long as justice is served, regardless of whether it's a conviction or an acquittal. Let's put their feet to the fire. If they really want to do justice, set up units in their office to investigate potentially problematic convictions and then do the right thing. Second, maybe set up independent innocence commissions like you have in North Carolina that are executive branch commissions that are designed to just look at innocence cases. And the third recommendation I make is a little more abstract, but I think important. We have to stop treating people behind bars as the other, as somehow different from you and me.
Yeah.
It's a we. They are our brothers, our sisters, our mothers, our fathers, our children. What separates us from a life behind bars and potentially being wrongfully convicted is really luck.
Yeah.
And to some extent, for white folks, it's white privilege
Sure.
and wealth. But for a lot of people, it's just happenstance. It really could happen to anyone. So instead of thinking about people behind bars as someone different, as people worthy of being condemned, think about them as true citizens like us who deserve to be treated like fully formed human beings and to continue to get the benefit of the doubt. Those are
Yeah.
some of the suggestions.
From your lips to God's ears, for sure.
Yeah, there we go.
Absolutely, that's real. One last question, then, Daniel. Let me ask you: if I'm innocent
Yeah.
and I want to reach out to the Innocence Project in my area
Yep.
for some assistance. What's the best petition I could make? What does my package needs to be when you see it first?
That's a super good, really important question, Sonia. So here are my thoughts. First of all, I would go. There's a group called the Innocence Network. I think their website is innocencenetwork.org that has contact information and lists for lots of different innocence projects across the country. So there's the big Innocence Project in New York, the famous one with Barry Scheck and Peter Neufeld. They just do DNA cases where there's biological evidence in the case that could prove you're innocent. Most criminal cases don't have biological evidence like that. You have to prove your innocence through other ways. So there are dozens of other innocence projects, often based on regions, that you can find on that website. So let's say first you've located the right innocence project, one in your jurisdiction. In your pitch, my recommendation is to be very sincere, but to be very factual in the description. I ran one of these projects for 4 years in Brooklyn, New York, and the letters I got that were very specific and detailed, describing the alibi, where they were, what went wrong, why they're innocent, those ones felt much more compelling to me and moved me than the ones that had a lot of hyperbolic language about the greatest injustice in the world. I often tell my students that understatement is more powerful than overstatement. A lot of people think if they throw a lot of adjectives and adverbs and exclamation points in a letter, that you'll be heard. I think it's the opposite. If you're kind of understated and proceed really clearly and slowly and rationally and explain why you're innocent, people are going to read it and they're going to find it more believable than if you just try to scream from the rooftop. Now, that's easier said than done because when you're innocent, you want to scream from the rooftop.
Right.
So you can really do both. But I think in making that pitch, I think it's really important to get into the weeds of your case.
Extraordinary. That's really, really good advice. I hope to never find myself in the situation of
I
needing
hope
it,
so.
but
And if you are, you won't. I'm representing you for free because you guys are great. So
Thank you so much. Daniel, I'm
you're
going to
welcome.
share the title of your book for our viewers on the screen here. They can find you, I'm sure, at Amazon, Barnes & Noble, other fine bookstores. Thank you so much, Daniel, for the work that you do. Please continue, and I just wish you much success. And the title, again, just to be clear, is Barred, Barred, Why the Innocent Can't Get Out of Prison. So thank you so much, Daniel.
Thank you
We'll
both.
have
That
you
was a
again.
delight. Take
You bet.
care. Bye.
Bye-bye. Fantastic, Deborah. That is,
Wow.
there's so much work to be done. I'm heartened to hear from Daniel about the work that is being done here. It just we need to 10x, 100x the
Yes.
efforts there just to solve this, to have a hope of solving some of this problem. But that is fantastic work that's going on there. So I know we've got just a few minutes, but if you would, Deborah, tell us the answers to the last quiz and what you've got teed up for next.
Yeah, we don't have winners anymore. But here's the last question. True or false? A motion to dismiss is an answer to a complaint. That is false. A motion to dismiss is a response, but it is not an answer to a complaint. You have to answer the complaint even if you moved to dismiss. And today's quiz, which of the following is the most accurate statement about venue in legal terms? A, venue is the location where a case takes place. B, venue is the state in which the courthouse is located. C, venue is the jurisdiction in which a case is being tried. Or D, venue is the legal jurisdiction in which the case was filed. Which is it?
Oh, I love that. I love that. I do miss having winners. That's
Yeah, yeah,
something we may need to move that over to social instead. But that's fantastic.
I
That is
agree.
fantastic. Well, that's all we have for you today. Thanks as always for joining us on Who Wrote That Up for You, and we will see you next time. Are you feeling beleaguered,
angry or afraid, as if things are spinning out of control and you're powerless to stop them? It's easy to just let things slide and hope they don't get worse. But they often do get worse. The thing is, you're not powerless. Our courts belong to us, and their purpose is to give power to the powerless. Don't let your grievances pile up without redressing them. You can handle this in court. Or, if someone takes you to court, you can take them to school.